What does your Chapter 13 trustee really think about your case the first time he or she opens your file? I'm Jonathan Ginsberg. I'm an Atlanta area personal bankruptcy attorney. And when you file Chapter 13, your case is going to be assigned to a Chapter 13 trustee. And unlike Chapter 7 trustees, Chapter 13 trustees, they're employees of the Chapter 13 trustee's office, the U.S. trustee. This is all they do. Chapter 7 trustees do it part-time. Chapter 13 trustees, it's a full-time job. In the Northern District of Georgia, there are currently 3 main trustees, and each trustee has 2 or 3 or 4 assistant trustees working for his or her office. And so when you file a case based on the judge that's assigned to your case, that will determine which trustee is assigned to your case as well. And then depending on how the particular office works, an assistant trustee will be assigned. So generally speaking, when a judge is assigned, we're going to know who the trustees are. And if you do a lot of this type of work, you get to know all the trustees. So what are they thinking when they see your case? Now, I've been doing this a long time, and I will tell you that I've interacted with literally dozens of Chapter 13 trustees, 7 trustees as well. And some I've even I will tell you that many of these trustees worked in private practice before, and some of them have worked in private practice afterwards. So again, you get to know these people on a more personal level to get an idea what they're thinking. My experience is that most Chapter 13 trustees tend to be pretty reasonable people. Some are hard asses, and they look at this as a way where they're cynical. They don't believe anything you say from day one. I think all of them probably are a little bit cynical, realize that in Chapter 13, only about 30% of the cases end up going through to discharge at the end of the case. So a lot of them, I think a lot of times the trustee looks at Chapter 13, they see this as a tool that the debtor is using to delay the inevitable or to simply delay creditor action. And so they don't believe a case is really going to work until it's been enforced for, say, 3 years. So that's why when a case is filed, the first year or two, the trustee is going to be much more difficult to work with than in year 4, where you've been through it for 4 years. Now they start to become a little more reasonable in the sense that they want the cases to work because it's already been 4 years. When you file Chapter 13, you are basically adopting a new business partner for your personal life, and that's the Chapter 13 trustee, because anything you do, if it's buying a vehicle, getting a major home repair, having an emergency, getting sick and needing to take a break from payments with the trustee, you've got to get permission from the Chapter 13 trustee. And the trustee is going to look over every page of your petition, but mostly they're going to look at your budget. They're going to look at the creditors you've listed, but they're going to look over everything in your petition. And about 30 days after you file, you and me, your attorney, we're going to have to go to a Section 341 meeting of creditors and answer questions from the trustee. And the trustee in Chapter 13, the job is to administer your plan. And again, Chapter 13 is a payment plan, and their goal is to see to it that you pay every dime that you have as disposable income to the Chapter 13 trustee's office. The trustee then gathers that money, then disperses it to creditors, and the trustee also gets, I think it's a 6.2% take. That's how they fund their office. So all the money that goes through the trustee's office, a percentage of it goes to the Chapter 13 trustee. Now, I will tell you that if your case is a 100% plan, where you're paying 100 cents on the dollar to all your creditors, you're going to have an easier time of it, because since you're paying 100%, although again, no interest on the credit card debt, which is one of the positives about Chapter 13, if you're paying 100%, the trustee is going to have less to worry about, because again, you're paying everybody. If you're paying it 1 or 2 cents on the dollar, then the trustee is going to look at it a lot more scrutiny, because their attitude is, you're not paying your creditors, we're going to try to squeeze you to pay more. Now, 25 years ago, when I started doing this, we'd file a Chapter 13 case in the plan, and we might see 3 or 4 objections or 5 objections. There was a problem with funding, or the case is running more than 60 months, or the debtor has not needs proof of mortgage payments. Just pretty basic stuff. And I even had a few cases back in the day where there were no objections, and you process them through, you go to the confirmation hearing, case is approved, and you move on down the road. Now, I will tell you that every Chapter 13 case I file, 1%, 100%, it doesn't matter, there are going to be 25 objections. It's become a lot more adversarial than it used to be, and honestly, for me, I don't know why. I don't think the cases are any more or less successful than they used to be, but the trend in certainly Congress has made it more difficult, and the trustees are a lot more difficult in terms of making the objections. So I'll give you an example. I pulled a recent objection on a case, and a lot of it's just documents that they want. Again, it can still be a term problem, or it could be a funding problem, something like that. But for example, if you list charitable deductions, you're paying your church a certain percentage, or you're paying $100 a month to church, they want to see proof of that. If you have an eBay business, even if you just sold a few things, they want to see all the receipts to see what you're selling. They may want to see 6 months of bank statements to see if there's anything unusual in your spending pattern. If you declared a certain value in your property, they want to know where that came from, and maybe a copy of any appraisals you may have. A lot of times there are service issues. When you file a case now, used to be the trustee and the clerk of court would send out notice to everybody. Now the attorney has to do it. They want to see proof, certificate of service of proof, and certificate of manner of service, and a MAC notice, which is basically when there's a material change to how a creditor is treated under the plan. They want to see that notice, and it's got to be done in a timely fashion. Again, the terms problem, the case is extending beyond 60 months. The payment allocations, the plans now, we have to decide how much each creditor is getting paid per month, and so if the claims come in higher than expected, the payment allocations may take us beyond the amount of the payment. So for example, if we're paying $1,000 a month and you're paying $300 of this one, $300 of that one, $300 of this one, $100 of that one, all of a sudden we're over $1,000 a month. So we've got to make that all fit. And again, if the claims come in higher than expected, we may have to file an amendment. A common thing I see is if you have a student loan you're paying directly, when that student loan is paid off during the court, let's say year 2 of your plan, we've got to provide for a step plan to increase your payment. We've got to have a specific language that says tax returns have got to be paid, or refunds rather, tax refunds have got to be paid to the Chapter 13 trustee. If your income changes, in other words, we have to file beforehand, when we file your case, we file for the means test a list of your income for the 6 months prior to the date you file. But if your income has changed and has gone down, but your income for the means test was higher, we've got to explain why. The trustee will object and say your income looks like it's understated. So the bottom line is, I would say this: when you file Chapter 13, what the trustee's thinking is, unconsciously or subconsciously, that this debtor is probably minimizing his income and maximizing expenses. How can I squeeze him for another $100, $200, $300 a month? And how can we increase the payment? And the second thing is this a 100% plan? Are we paying 100 cents on the dollar? If not, is there any way I can squeeze the debtor and his attorney to get to 100%? So I will tell you that whatever your plan calls for, the number, don't assume that's going to be the final number. The trustee and possibly creditors are going to try to squeeze you to increase what you pay to creditors and increase the Chapter 13 plan payment. And the second thing, if you're not paying 100%, they want you to pay 100%. That's what they're also going to be trying to force you to do. So Chapter 13 has become somewhat more adversarial than it used to be. Still feasible, still possible, but you're going to pay more than you want to pay, and you're going to, again, it's going to be a 5-year plan. Very rare you'll see a 3-year plan. And like I said, during the course of it, if there's any glitches, anything you need, I recently had a case where my client called me and said, I wrecked my car. What do? We got to go through a whole bunch of rigmarole, file motions, and be able to get approval for an outside loan to get a replacement car. Everything is a pain in the rear end. So just expect that with Chapter 13. In exchange for that, you can stop a foreclosure, stop a repossession, stop a wage garnishment, but it is not simple and easy, and it's going to be a fight. Once you get to 3.5, 4 years, all of a sudden the attitude starts to become a little more agreeable by the trustees, but until that time, it's going to be somewhat adversarial, and just be prepared for that. So, if you have any questions about Chapter 13, you can reach me at 770-393-4985. Happy to answer your questions. My website is atlanta-bankruptcy-attorney.com. A lot of great information there, and until next time, this is Jonathan Ginsberg wishing you the best. Thanks a lot. Hi, this is Jonathan, and I hope you found this video helpful. I'd like to invite you to download my free Debt Destroyer Survival Kit right now. I've packed my survival kit with answers to the questions I've heard from clients for over 25 years here in the Atlanta area. Inside the survival kit, you'll find clear, easy to understand answers to critical topics about how to solve debt problems once and for all, including how do I protect my stuff, my house, car, and personal property if I file for bankruptcy? Are there any legitimate alternatives to bankruptcy? Will I ever get credit again, and if so, when? What mistakes must I avoid to get the most benefit out of bankruptcy? You can claim your copy right now by visiting my atlanta-bankruptcy.com website. And you are always welcome to use the email form on my website to ask me anything about debt and personal bankruptcy in Atlanta. www.atlanta-bankruptcy.com. And as always, I wish you the best.